Good morning, everyone. Welcome along. We'll make a start because we've got a jam-packed session for you today. This is part 2 of the GDPR Virtual Masterclass brought to you by the Business and Local Government Data Research Centre in partnership with Southeast Creatives. Together, we're supporting organisations across the world use data effectively. If you're new to Zoom, this is just what you can expect from your Zoom experience with us today. If you've got any questions, please type them in the question bar, which you can find at the bottom of your screen. There's also a chat facility, which some of you have already used today to say hello and let us know where you're from. Please feel free to type any comments as we go along. We always enjoy seeing those and corresponding with you throughout. If you need to adjust the audio settings, you can find that in the bottom left-hand corner. And if you want to make the screen larger so you can see the slides full, you can find that in the top right-hand corner. Very briefly, the Business and Local Government Data Research Centre can help you use data effectively. We provide free training, grant-funded data analytics projects, webinars, workshops, and much more. If you'd like to find out more about any of these, please visit our website or contact us directly, and our contact details will be at the end of the presentation. This is part 2. So yesterday, hopefully you joined us and you learned all about GDPR, the basics, where it came from, why it's so important, what it means beyond Brexit, the key people you need to consider within your organisation when it comes to GDPR, who and what is protected, the many forms of data, and we had a great Q&A at the end. So today we've got lots more coming up. There's a jam-packed session, and I'm going to hand it over now to Dr. Guinchard, who is a leading expert in this area and will be leading today's session. So over to you, Audrey.
Thank you, Laura. Thank you, and thank you for joining us over the first time or again. I'm really pleased. I'm going to share my screen to get the slides and taking it from where Laura left it. I need to put the, that's it, much better, the full screen. I was just saying that I'm used to have the presenter view when I teach, and it's sometimes a bit difficult to just have this one slide and nothing else. So I was looking and thinking about my time in number of slides. So yesterday we've been through what was the GDPR and what was personal data. So you know, GDPR is General Data Protection Regulation. It comes from the EU, so the European Union, the one that Brexit is all about. It doesn't come from the Council of Europe, which is linked with the European Convention of Human Rights, and which is a completely separate entity. And the UK is not normally going out of the Council of Europe. So the European Convention and the European Court of Human Rights will still apply despite Brexit. So this is, GDPR is the EU regulation. With Brexit, there have been questions about whether it applies or not. So yesterday we saw, sorry, I'm just going to close my door so that we don't hear the shouting in the household. We've seen that with Brexit, you know, the UK got out of the EU on the 31st of January. And the GDPR was until then directly applicable. We are still in a transition period, so until the 31st of December, we are, you know, under the GDPR rules. So the question, I think, with Brexit is what happens after the 31st of December on the 1st of January. And that's where the Data Protection Act 2018, which is a UK legislation, confirms that normally the GDPR should apply. And in any case, even if the UK wanted to change, they cannot lower the standards because the EU requires everybody to comply with the GDPR. And that's why we had 10 days ago the Schrems 2 case, so where the agreement between the US and the EU was struck down because the agreement was too weak and not complying with GDPR. So really, that's what we've seen, plus the definition of personal data, which is identifying people directly or indirectly. So the question that we put today, before we get on really with the content, is: did you join part 1 of the webinar, so yesterday's session of 1 hour? It's just for us to give a little bit of an idea. It's for me also a way of thinking about how I can present, as we went through 2 key elements, what the GDPR is and what personal data is, with sensitive data and other forms of data. So probably the poll will appear. Yes, okay, thank you. So for those who were not present yesterday, don't panic, you should be able to understand it. The main thing that we have to bear in mind is the question of personal data. GDPR applies when we've got pseudonymized data. So it's not about having a name, it's about having the possibility to re-identify somebody through data points, and that means GDPR is then applicable. So yesterday at the very end, we said that there was what I think is a 4 steps process. I think it's an easier way of looking at GDPR, because GDPR is a 200 pages legislation really, so it's huge. And in certain ways it's complex, but in other ways it's pure common sense. So the first step is about mapping the data flows, minimizing the data collection and the data use, not maximizing, and justifying that use. So effectively you're looking here at articles 5, 6 and 9 of the GDPR. If you ever want to read the text, which is not that complicated, and I don't think it's distortion of the fact that I've been working on it for a while. Those articles have also been written with in mind people who are not lawyers. So Article 5, 6 and 9 of the GDPR is linked really with the first element, the first step. Then I think once we sorted out this, there's still a couple of layers to think of. And the first one is linked with the key people. So yesterday we saw that slide with key people. We'll see it again today with more details about processors, joint controllers, people who are employees, volunteers in the organization. And really, it's about thinking about who is custodians, what people have to do, what are their responsibilities, not just with step 1, but more generally to prove compliance. Usually when we do those first 2 steps, we end up realizing that we have risk. There may be minor risks, some may be higher, but that means that it's best practice to assess the risk before they happen. Before they realize, and then obviously think about steps to mitigate, like DPIAs, which is data protection impact assessments. And overall, we must be transparent to users and regulators. So to users, I think a number of you probably are quite familiar with privacy policies, at least when they have to draft them. I think as users, we're a bit less compliant in the sense that we don't necessarily read the privacy policies of websites and so on, but that's what they're meant to be transparent, and obviously transparent to regulator in case the regulator wants to check what an organization is doing. So we're going to go through those 4 steps, with the first one now really about how do we map those data flows, how do we minimize, what are the key questions that we really need to think of. And I tend to see the process in that circle. So you start on the top with the data. So you think about the data you want to collect or you want to use, or both collect and use. You think about the actors, who has access to that data, for what are the different people involved. And then naturally you go on to the next one, because if you ask who has access to the data, you think, why do they have access? Why would I grant access? So it's the purposes. And then there is the issue of timing. How long is that person going to have an access? How long should I use that data? Should I think about deleting it? Do I archive it? And then overall, can I justify this legally, which is not the same as purposes. Purposes are indeed immediate reasons, but they don't always match the legal justification. So we have to think about legal justifications, which is Article 6 and Article 9. And if you like, you have the little articles written at the bottom left, Articles 5 and 6 and Article 9. Data, actors, purposes, time, that's all Article 5. Article 6 is essentially legal justification, and if you have sensitive personal data, so data which is linked with ethnicity, health, religious belief or lack of religious belief, philosophical belief, sexual orientation, biometrics, that's also Article 9 on the top with legal justification. If you want any of those principles for processing, which are in Article 5, you will find them on the guidance of the ICO. Literally what the ICO has done with GDPR is not to have a booklet, but to have an interactive website where people can click on the principle. So principle of data minimization, of actors, of purposes, timing, and so on, and see the guidance for each of them. So justifying the collection and the use of data, because it can be very abstract, I tend to say to start with a privacy policy. Look at your privacy policy and think about what type of data are you collecting and using? Why do you want to use it? Don't be vague, be very specific if you can. At least for yourself, you can have two types of document, one that you keep for your own organization and one that you're transparent for the user. And then, you know, everything else, the actors, the timing. So it's a good way of thinking about data protection by starting with what will be one of the key document, not the only document, but the key document, which is your privacy policy. So I think the terms of data minimizing, and just it's not too difficult to think about what data do I need, and by what we mean by I need is my business, my organization cannot survive without that data. And then we have to think another step is it will be really good for the business to have it because it could expand. But then how can I minimize again that data? Once you've done that with the actors, usually you're ready to do the purposes. So purposes can be, you know, we're all familiar to that. If you go shopping on the net and you have to register for the first time, you may have to give your name, an address, a postal address, as much as an email address, maybe a telephone number. It is not, for example, necessary to ask for the age of a person. You can put above 18. If you want demographics, that might not be necessary for registration purposes. That might be more for marketing. And that is where the purposes have to be quite clear. You can have data that is used only for one purpose. You can have the same data used for several purposes. So registration on a shopping website, you're going to have the name and email address for registration purposes for the person to be able to log in. You're going to reuse that data for shipping the goods that a person just bought as much as for payment. registration, payment, shipping are all purposes, and they're different purposes, and you can see here that they are specific enough. They have to be explicit in the privacy policy and in your documentation, and obviously they have to be legitimate, but I think I don't think that's an issue here. Something that is not illegal. Specific is really something that people struggle with. And I know it's difficult because the giants, I call them the giants of the web, are not specific. When they say to improve the services we provide to you, sorry, that's called an umbrella purpose, because it's like a big umbrella, and it actually means that you have at least 2 to 10 different purposes gathered into that sentence of improve the services we provide to you. And that's not specific, and that's not meeting Article 5, 1B of the GDPR. So it's really about being as specific as you can, certainly for yourself and for documentation in relation to the regulator. The other thing that you need to think of is what would be the reasonable expectations of your customer or your person using your services. If the person would not expect it and cannot reasonably expect it, then you should not. You should be very, very careful about saying that I'm going to use the data for this purpose, if that is not within the expectation of the data subjects. Now, reasonable expectations work. You can collect data for statistics purposes, for example, for your own business. If the same data, you want to reuse it slightly differently because you want to change the way you do your statistics, it's probably within the reasonable expectations of the data subjects. And even if you didn't tell exactly how you want to do the statistics second time, you probably are within the reasonable expectations. So in GDPR terms, you are linked with still Article 5, 1B, but you can also refer to Article 6.4 of the GDPR. And I just realized we did a big mistake. We forgot the R of GDP. So it's not a GDP with the profit of the state. It is GDPR, Article 6.4. That is the purposes. So I want to registration for my example, shipping, payment, and so on. Now, all this needs to be fitting within a legal ground. So a legal ground is the technical term in the GDPR. Think about legal justification if it's easier to remember what it means. And that's essentially Article 6, Article 9. And then you have some specifications for certain elements. So for consent is Article 7, and for children's consent is Article 8. So 6 to 9 is linked with legal justifications. Now, Article 6 has different justification. The first one on the top, like for Article 9, is consent. And then underneath for Article 6, you've got contract, you've got vital interest of the data subject. So vital interest is simply emergency health issues. So it's A&E in the hospital. Don't ever think it's anything else. It's only A&E. You also have legitimate interest of the company or the organization. You've got when you have a legal obligation, and that's strictly interpreted. So for example, compliance with the Equality Act. And you've got a couple of other grounds that you can think of. Overall, you've got, I think, 7. They're in letters, A to G. So often on the top, you've got consent of all those grounds. So consent, contracts, legitimate interest are the most common. Now, consent tend to be overused. In a way, we'll see that in a couple of slides, but the reason I say this is because consent has a very, very specific meaning in the GDPR, and it's not the same requirements for consent in the GDPR, that you would have consent in the contract, because we agree to a contract. It might be the same word, consent. It's not the same meaning. It's not the same definition exactly. You have overlaps, but you do not have exact matching of the two words. Same for health in the healthcare sector. Healthcare sector is quite familiar with the duty of confidentiality. You know, as a patient, your doctor has a duty of confidentiality. There is that notion of the patient's consent. That consent has not the same meaning and the same requirement as for GDPR. So it's same word, two different things, and that's really confusing for many people. So GDPR consent, what is it? It's defined in Article 411, and it means to be freely given. It has to be specific, informed, and unambiguous. So of the data subject's wishes. And it means clear affirmative action. So let's start with by the reverse. What is a clear affirmative action with unambiguous? It means that you cannot use pre-tick boxes. You do have to use boxes where the data subjects will tick. And then it needs to be informed. So it's not just saying, well, we're going to improve the services to you and therefore you consent. It has to be more detailed than that, because informed is literally linked with specific. The more specific you are about your purposes, the more informed the consent is, and the less likely, the more likely the consent will be valid, and the less likely the regulator will have a go at the organization or will fine you. And that's the tricky bit, and that's where often consent fell under the GDPR. It's freely given. Now, freely given means that the person can actually refuse, and not refuse and not use at all the services. That is not free consent, which is the issue of, a lot of the websites, and you can think of social media here, issues where they say they use consent, and actually it cannot be consent, simply because you cannot refuse. If you refuse, you cannot use the social media platform, and therefore it should be contract, it should not be consent. So freely given really means that notion that the person can refuse and truly reject. There are many issues, especially for cookies in that aspect, but the one that I tend to also say is freely given is linked with Article 7, and it means that if you have an imbalance of power, the likelihood that the consent will be freely given is very slim. So you do have to think about the relationship you have with your data subjects. Are they in a position to refuse? And I'm still able to provide a service. The service may be less wide, less broad, or tailored to a number of restricted features. That's fine. But it needs to be a true consent. So it's really, really tough to meet GDPR consent. And in the healthcare sector, for example, because I think a lot of you are from the healthcare sector, you can meet the ethical consent, you can meet the consent under duty of confidentiality, and you can fail consent under GDPR. So really thinking about those different layers and what are we talking about when we say consent. Are we talking consent under GDPR, consent under other areas of laws? So really consent has to be meaningful, and the way of recapping it is this slide. So if you look at the top, it's free, real choice, no imbalance of powers. If you have an imbalance of powers, try to put safeguards into place so that the consent can remain free, can remain meaningful. Explicit and unambiguous, so no pre-tick boxes for the data subjects. They have to tick and they have to be informed, which means that you have to be specific, consent for which purpose. So it's linked with purpose limitation. So really it's that thinking about GDPR consent, having those 4 characteristics, and not exactly the same as consent in contract law or duty of confidentiality, for example, in healthcare. That can also be in other professions, actually, not just the health service, the health sector. Now, the big data aspects, and I just mention it because some of you may be familiar with data analytics and what it means. The main issue with big data and data analytics is that we don't know what we're going to find. And if we don't know what we're going to find, we cannot foresee the purposes, the future purposes. So it becomes really difficult to rely on consent, and consent really at the time of collection of data or before doing the data analytics, it's going to be about consent to do the analytics. And if you use consent to do the analytics, then you're going to have to go back to your data subjects to say, look, now we've done the analytics, this is how we would like to use that data again. Do you consent? So it's really the challenges of exploiting big data and data analytics when we use consent is that it's very difficult to be specific, to be informed. Again, in the healthcare sector, it's called often broad consent, but broad consent is only tolerated for a limited amount of time with the GDPR. It's actually Recital 33, if you're ever curious about it. Otherwise, it's not tolerated. So again, try to think beyond consent because it's a very complex legal ground, legal justification. And I think that's because consent has evolved around complex relationship and regulations. Consent often comes when you have a whole background and set of regulations that often the data subjects doesn't even realize. Often when you have an imbalance of powers, like in employment law or in consumer law, so when we're buying products, because consent in contract law was impossible, it was not working because of imbalance of power. Effectively, the law changed and we moved from contract law to create a new field of law, employment law, and then recently, over the past 30 years, we created another field of law, which was the consumer rights law. And that gives you an idea of how consent is complex in something that is not even the GDPR, but the GDPR, I think, doesn't change the fact that those relationships are complex and consent is a very crude, often inadequate way of justifying the use and the collection of data. So we really have to think about that, especially online. The online platforms tend to be acontextual, so they tend to be inadequate in terms of managing consent. And that's where I come back to my original point. Do not use consent unless you really have to, and there is no other grounds that you can use. Try to, instead of thinking of consent, try first to think about the other legal grounds. So in Article 6, I mentioned contract. You also have public interest, but that is also, again, very specific. Emergency care, the vital interest of the data subjects. The one that you're more likely to use, apart from contract, is legitimate interest. Public interest can work if an organization, for example, got a contract with the public sector to deliver some provisions that are themselves statutory based. That's often the healthcare sector, the social care sector, but that can be other sectors also linked with crime, for example, criminal justice. Now, for sensitive data, I'm not going to go down too much into detail, but Article 9 has exactly the same logic, except that every processing is an exception. So again, very strict interpretation. But effectively, you've got consent, but you've got vital interest, you've got research, statistic, and history and archiving purposes. You have public interest. You don't have contract. You've got the if you got a trade, if you're in a trade union or a charity linked with religious belief or political organization, then you've got a specific ground to process the data of your organization linked with political belief and so on. If you have sensitive personal data, so health data, political data, and so on, you do have to comply both with Article 6 and with Article 9. You can't just comply with Article 9. It's a UK specificity. The rest of the EU member states I should say, the EU member states, as the UK technically is not anymore an EU member state, do not necessarily require compliance with both. It's a way of protecting the data subjects better, I would say, more strictly. Issue of further processing. So when you have collected and used data and suddenly you think of using it for a very different purpose, something that you never thought of at the time of collection, can you do that? Is further processing. The key answer is yes, but you have to prove a very strong connection with the original purpose. If you can't, then the only ground that's going to remain available to you is going to be consent, which raises its own set of issues, as we have just seen. So that's, if you like, about minimizing data collection and use, justifying them. That's our first step, really, Article 5, 6, and 9 of the GDPR. Now, once you've done this, you need to think about the relationships with your other key people that you're using and working with. So it can be an IT service if your organization is big enough to have even just one employee being the IT service. It can be the cloud provider, including for storage. It is also a question, you have to also think about the questions when you have a page, if you have a page on Facebook to promote your activities. It's quite convenient, but you are going to, but because of Facebook, you're going to agree to collection of data, and you have to think about that relationship with Facebook in relation to your customers. You also have obviously I'm taking Facebook as a legal case, but you have all the social media websites to think of, and it could be LinkedIn, Facebook, Twitter for the most known social media. So the big picture here, I think, is to think, and we've seen that yesterday, so for those who were present yesterday, that's familiar. So we have to think about ourselves when we process data as custodian of data. That really put the emphasis on the fact that we are here to protect the data subjects. We are not just here to control and do what we want. We are here to process data with in mind protecting the data subjects, not just in mind our organizations, profits, benefits, advantages, whatever you want to call the positive for your organization that represent processing data. So it's about processing data for ourselves as controllers, but it's also bearing in mind that that has to be balanced with that notion of being a custodian, protecting data subjects, enabling them to be protected when we process data. So you have two key concepts, and in between you've got a third one. You have controllers and processors. Controllers are the ones who determine, so identify the means and the purposes of processing data. So purposes are exactly what I explained earlier with Article 5. So in my example, it was registration on the website, payment, shipping. and the means, so how it's going to be done. And it's not just identifying that, it's to say to anybody who is going to help doing this and which is not part of the organization, how and what they're going to do. So it's identifying and controlling, determining in that sense, but determining with this in mind that the data subject has to be protected. As a controller, we are often using processes. It's the supply chain in business terms, really. And those processes are liable, more so under the GDPR than they used to be, under the directive and the previous DPA. They have to maintain the documentation, they have to conduct assessment, they have to pay fine, as well as the controller if there is a fine, which I hope is not going to be the case. They cannot hire another processor, so their own supply chain, they cannot do so without asking the controller and without the controller being involved in that supply chain. So you can see from the processor point of view, they have a huge responsibility now. For the controller point of view, it's also a responsibility because it is about asking questions about the supply chain and not turning a blind eye about what the others are doing just because they're processors and they're not directly employed by you. You didn't choose them necessarily directly if it is the third or fourth processor. Now that relationship is governed by a contract, and the contract is also governed partially by the GDPR in terms of what the data is processed. Now the role of the processors is new in the sense that processors have to be proactive with the GDPR. So before the GDPR, effectively controllers dictated to processors and processors really had to obey. With the GDPR, processors have to actually point out to controllers the decisions that the controller took that may actually be non-compliant with the GDPR. So as a controller, your interest is to choose a processor that has the ability to actually comply with GDPR and think in those terms, rather than a processor that is not really aware of GDPR and finds it difficult. If it is the case, and that can be the case for the purpose you want to apply to hire them, then you do have to put safeguards in place to make sure that the processors are complying with GDPR, have all the structure in their organization to comply with the GDPR and to comply with what you order them as controllers. So it's really processors are what I call, auxiliary custodians. They are there to help the controllers to comply, to support the controller to comply and be proactive. Now, for many of us, it's, I'm just really a small business, a small charity. I don't have the big budget that the big giants on the internet have. And it feels often as a David against Goliath type of battle, really. And I would say this is where, if you like, the logic of the GDPR is you have to prove that you ask the questions and you've tried to resolve the questions to the best of your ability. So what really matters is your audit trail. What is the documentation that you have put in place to show that you asked those questions, that you got those answers, that maybe the answers were not exactly what you wanted, but it was very difficult, for example, to change simply because the processors refused, for example, to change their clauses in the contract. And it's really demonstrating that awareness and that attempt at resolving issues that matters. The ICO, so the UK regulator, as much as the EU regulator, are fully aware that a lot of people are David, a lot of organizations are David, and that the big giants are Goliath, and it's tough to get them to change, especially if they're using standard contractual clauses, standard contracts. So they do not necessarily expect the right answer, but they expect serious efforts in compliance. And I think that's the most important thing to remember. Trying to really think about, can I minimize my data collection and use? How can I get my processes to comply, even if they are the giants? So it's asking big questions, and the GDPR is there to help you. It's something that tends not to be seen, and it's certainly something that I've noticed is hardly ever talked about. But Article 28 of the GDPR is effectively setting all the processors' duties, and by that, it is setting what the controllers can do. And the questions the controller can ask. That is asking the processor to check that not just they have secured the data, but they are only collecting and using the minimum data, that they have all those elements in place to comply, that they review regularly their privacy policies, that they review the time frame of using the data, and so on. And then they have the structures also to inform the controllers if something is going wrong, if there is a potential for violation of the GDPR. It's really, really important to think about this. But Article 28 is there to support you. You can literally use it as saying, look, this is your obligation and this is my obligation. Same thing for Article 29. And then for duties on security of data, so roughly avoiding unauthorized access, whether through hacking or just simply an employee, leaving a USB key with personal data on it in the train or on a coffee on a restaurant, coffee shop or restaurant. It's Article 32, and both controllers and processors are on equal basis here. They have to both have security structures here and planning. Notification of data breach. So if there is an authorized access, you need to think about Article 33. Is there a need for a data protection officer? In most organizations, no. If it is small, that is not an obligation below 250 employees, which represent about 90% of businesses, so an organization. So for many people, a data protection officer is not an obligation. Now, it's not because you are a small organization that you should not think of having somebody who is part of their job description, maybe about thinking about data protection and being a bit responsible, or looking at the business or looking at the organization and how they manage data protection, simply because that avoids diffusing the responsibility among very many people with effectively nobody taking responsibility, and then you hit a data breach, and then you get the bad side of the GDPR. So really, it might be a good thing to think about naming somebody. It's part of their job description, so it's part about what they do, and they are recognized, their work is recognized as data protection, maybe not officer, but contact point. That might be a way of putting it. If you want to know more about this, go and see the ICO checklist for processors. Put the link there. But as a controller in your organization, you're not alone. You are maybe the primary custodian, but processors are auxiliary custodians. So be aware of this. Have that dialogue with them. Now, the big, what I call the big giants, and that the issue of using Facebook, LinkedIn, and Twitter Facebook tends to get the highlights simply because more people use it than LinkedIn, and Twitter is more public, if you like, orientated, so people tend to share less personal data. Now, it doesn't mean that the 3 and other social media platforms are not problematic, but it tends also to be the ones which have those little buttons. If you look at the slide on the right, you see those little circles in blue with in, F, the Twitter, and so on, Instagram. So think about these when you use them, because those little buttons do collect data. And depending on how you use them and how Facebook or the company that has those logo using them, you will be responsible. And those companies like Facebook may not be considered as processors, but as joint controllers as much as you. So you have different cases. You have now 3 cases at EU level. I know the UK has gone out of the EU, but the GDPR will always be interpreted with the EU case law in mind. The UK won't be able to escape that. The only thing it can't do anymore is to influence the discussion directly by being part of the EU. So the case study, I think the most representative, because it's also our life, I think, it's a German academy school, so a German school for high school that had a fan page book on Facebook, on Facebook. And what it shows, how they chose to use the Facebook page and the data that they try to collect, so the data that they agreed to collect was Facebook Insight, and effectively it installed cookies, and even if a person didn't have a Facebook account, their personal data would be collected. And that was considered in violation of the GDPR. And more importantly is that the school was considered joint controller with Facebook. Not equal responsibilities, effectively joint controller, and at the surface you think equal responsibility, but because of the way Facebook set it up, effectively Facebook was more responsible than the school, but they're still both responsible, which means that the school got effectively a fine. And that's not the position they want to be in. So you do have to read the small prints in when you look at Facebook and you use Facebook. The next step, I think, beyond this, and you can see immediately why I said it's assessing the risk, is because when you look at those questions, suddenly you start thinking about, okay, I decided to collect this data, I'm using those processors or those joint controllers. What are the risks that of the data flows, of the data circulating between this organization and within my organization? So it's about assessing, that's the third step, assessing the risk and mitigating them. So I did a summary here, but you will have to think about, I would say at least sketching the risk roughly for your organization. I think the more you go into detail, the more prepared you are to face those risks and to mitigate them. So I think it's good practice. It might not be the urgent thing, but it's not something you should do in 2 years' time. It's something you should do in the next 3 months, really. You have different types of risk. You have surveillance. It's not necessarily applicable to all organizations. It depends on the way you collect and the type of information you collect. You have intrusions, so when you have hacking with a virus in your organization circulating on the computers, especially if the computers are used for personal purposes in addition to business purposes, and if the person doesn't even use 2 different accounts, one personal and one professional. It's about lack of security. It's about secondary use. That's a risk. If you're reusing the data, but you didn't say to your data subjects, you didn't tell them about that secondary use. Today we can think about risk of discrimination. There are many risks. I think you have to think about assessing them. As I said, we need a data protection officer? It's a requirement if you're a public authority or body, if you do large-scale processing, and if you process sensitive personal data, so Article 9, health, sexual orientation, political belief. Anything else is not an obligation. It's still good practice to have somebody who is a bit like the contact point and who does the training, for example, on data protection, who has that discussions in project about, does it have an impact on our compliance with GDPR? And mitigating is, what do I do? Who do I contact if there is hacking, which is the most likely thing that will happen to you? Hacking, unauthorized access, it's not a matter of whether it will come, it's a matter of when it will come to you. You will be hacked. In cybersecurity circles, we know it's not a question, it's just a question of time, not a question of whether it will happen or not. So the last thing, and we're reaching the end of the session already, I hope it hasn't been too heavy, is the fourth step, which is to be transparent to users. So I reused, it's not my slide, I reused something, you have where it's taken from. It's actually an organization in Ireland, which puts here all the consumers' rights, the GDPR rights that often match actually consumers' rights. So about, access to data in blue, data portability, the fact that they can ask their data to be transferred in a format that is usable elsewhere. So not just giving the data to somebody, giving it so that they can reuse it. Correction or right to erasure, to modify inaccurate data, that can be really important. You can think about credit agencies, organizations where you need to be able to make those changes. The erasure or right to be forgotten, a lot of you heard about Google and so on with the links, but it's not just Google, it's any organization may have to comply with the right to be forgotten. And it's not to be confused with the right to withdraw consent, even if it can be very similar. If you use consent, obviously it means that they can withdraw consent at any time without questions being asked. So that's the main rights for your consumer. For the regulator, compliance means that you have kept an audit trail. So you have documentation that shows you discuss data protections. That can be internal meetings. It will necessarily be in addition to the privacy policy that you may have for your website or your Facebook page and so on. It is also about, if using third parties, referring them to the privacy policy and not just say to the consumer, go and look at their website, literally give a link to that privacy policy. I sometimes say that if you really want to be a good citizen or a good custodian, give a short explanations of what the third party policy is about, because that helps the consumer understanding what is going on. And you have to not forget that you've got a registration fee to pay. Not everybody has to pay it. I have to say it's totally complex. I just don't understand why they did it this way. Just do the self-assessment on the ICO website. Take a screenshot of that assessment, because I'm not sure they send it by email. And at least you know where you stand, whether you have to register or not. The ICO is quite strict. I've noticed that they issued quite a number of fines for not registering. which sometimes I feel like it was a bit unnecessary. They should let people know that they haven't registered, ask them to register, and then come back to them and see if they have done so. So ensure you have all your documentation that you're registered. So the questions before quickly going into what happens if there is no compliance or poor compliance. So what is the maximum fine for not complying? It's a maximum, by the way, remember, which means that it's not necessarily what will happen in practice. The regulator does not aim to impose a maximum each time. So take a little bit of a few seconds to answer the poll. It's linked with the next slides on the fines for lack of compliance. Oh, that's interesting. For me, that's really, really interesting, because the first answer is 20 million euros, 43% think it's applicable. And that is the GDPR indeed. That's the maximum under the GDPR. And the 500,000 euros that the other 43% put is actually if you replace euro by pounds, by sterlings, it's actually the old maximum that was before the GDPR. And the annual turnover is important because it's not just 20 million euros. Actually, we will see that with the next one. It's 4% of your worldwide profit annual turnover. So it's ever 20 million euros equivalent in sterling, or the 4% of your annual turnover. And that means it's the maximum that will be taken, whichever is the highest. 5, lack of compliance, so it's up to, it's the highest. It doesn't have to be that. The regulator is not going to go for 4% if you're a small organization. It's going to have a meaningful fine that does not bankrupt your business, roughly. So before the GDPR, it was the maximum of £500,000. The ICO has done it over the last 2 years before the GDPR came into force. You have the TalkTalk hack of 2015, which is effectively the reason why TalkTalk was hacked. It's simply because they didn't audit the security of the databases of the companies that they merged with, that they bought back. So effectively, by merging with other companies, not doing the audit trail, they brought themselves the hacking issue, and they got that big fine. Same thing for Facebook with Cambridge Analytica. Facebook really turned a blind eye of how third parties were using its web page. And that's got them in that trouble. Uber did the same. Simple lack of security. They should have known better. But again, a lot of companies don't prioritize this. Now, with the GDPR, for the same facts, you see immediately the difference, because instead of 500K, they got British Airways 183 millions, which is not a small amount. So really, same thing for Marriott, a bit less, but it was the same type of breach. It was basic security. So when you think of risk, especially of security risk, think about what are the containment measures that you have in place. What is your duty to inform your customers, how you're going to do that. Have a plan before it happens. It makes your life easier. When it happens, you have to act so quickly that it's very difficult to think objectively about what you have to do. Now, remember, GDPR is like any legislation. It has grey areas. Legal certainty does not exist. That's why lawyers are so annoying, and they answer by "it depends." No legal advice is foolproof, but GDPR is very much about common sense and allocating liability. So today you should have seen enough to make you think and to go into the right direction. If you still have questions, then I think just ask, because what they don't want to see is just this. They don't want to have somebody on the phone to say, oh, we are completely compliant with GDPR. We just modify a little bit the privacy policy, get a few opt-in emails to say, do you consent to use your data? And that's it. That's not what GDPR is. It's much bigger than that, as you've just seen. So another way of thinking about your compliance is thinking about the philosophy of the GDPR. It gives more rights to the individual. It brings a heavy involvement of controllers and processors, especially processors. They're there to help you. They're not there to just be passive. The huge fine is just the reflection of, it mirrors that emphasis on more rights on the individual, more involvement of processors, and privacy being a public good, as well as no discrimination against people. It's a public good. It goes beyond the individual. If it benefits the individual, it benefits society. So I'm slightly over time. It was a tough session today. I think I'm going to leave it to Laura to share a little bit about the more opportunities. And then I'll take a Q&A if you're patient enough.
Wow.
Time.
Thank you, Audrey. That was a whistle-stop tour of how GDPR really does apply to your organisation. Thank you so much, everyone, for joining us. And I just wanted to bring to light the other opportunities to benefit from the free support we provide with a few more webinars. With next week, we've got creating your data strategy. And of course, data protection is an important factor to consider in that strategy. In August as well, we have how to conduct a data audit, and then moving forward to October, we've got how and why open data is useful. We've got the visualization of data, so turning those numbers, those words into visuals, infographics and more in November, and then social return on investment all the way in 2021. We've got lots more opportunities coming up. With next week, we've got your data strategy, which will be a great workshop, including GDPR as a foundation there. Then we've got how to conduct your data audit, which is later on in August. Then in October, we have how and why open source data is so useful to you and how you can make use of it. Then over in November, we've got the visualization of data, how to turn those numbers and those words into really engaging infographics and more that really do tell a story. And then all the way in 2021, we've got social return on investment. These can all be found on our website, blgdataresearch.org. We've got more opportunities, including how to conduct impact assessments and create the right evaluation forms to really make sure that you are using best practice, exploring text data, evidencing need for your services, and how to evaluate during times of social distancing.
That's it. And then if there is demand also, I can, because I mentioned cybersecurity, I can redo a cybersecurity one if people wish to. And I think the next slide is this one, yes.
If you were lucky enough to complete part 1 and part 2, then you can apply for your certificate of attendance. All you need to do is email your contact details to blgdataresearch@essex.ac.uk and I'll be picking those up to you. A cybersecurity workshop that Audrey referred to was conducted earlier on this year and can actually be found on our YouTube channel if you'd like to listen to a recording, but we can certainly look at doing a repeat session in the autumn as well. As I said, this is just one of the many ways we help organisations across the world. We also provide grant-funded data analytics projects where we analyse your data to help you achieve the goals you need. If you'd like to find out more about our work, please visit our website or any of our YouTube, YouTube, LinkedIn or Twitter accounts. Now we'll move on briefly to the Q&A because we know we're running slightly over time. And we've got some great questions coming in already, Audrey. So I'll be handing it over to you if you want to click onto the next slide.
Yes, that's it.
Thank you very much. So does a small local charity have to have a policy, a privacy policy? Great question there coming in.
Normally, yes, because that's the main way and the easiest way of complying with your obligations under Article 12, 13, 14 of the GDPR. Now, it doesn't have to be a long document privacy policy, especially if you're not managing, if you're not collecting lots of data. I think there is a question where, you know, the organization only has names, addresses, and emails. You can just be very simple and say, this is the data we collect, these are for the purposes, this is the legal justification. If you have questions, please contact us, you know, and that's enough. A privacy policy doesn't have to be a long document. Actually, sometimes a short document is more efficient than a very long one where nobody reads.
Thank you, Audrey. We've got another great question coming in here. Just wondering how far GDPR extends to business email addresses. For example, can you sign up colleagues in your own organization to your company's newsletter without asking their permission? Oh, a complex one there. Thank you.
They're your employees, but as employees, they are still data subjects. So you are still having to see what they do and your relationship with them, both as your employee, part of contract law, you know, your employment contract, and under GDPR. So I would say yes. I would say, you know, it might be a reasonable expectation to be signed in automatically, but I would say that you know, if it is reasonable expectation, which probably is likely, unless it's pure marketing, I would say at least you need to allow them to opt out here, so that if they don't want to receive the newsletter, they don't.
Great. So what problems will arise when the only data we collect is names, addresses, and emails for the purpose of contacting members? Sounds like a membership organization there.
Yeah, I would say the main risk for you is unauthorized access. It can simply be, unauthorized access is a very wide term to mean anybody who should not see that data has accessed it. That can be having a USB or a mobile hard drive floating around, left on the seat in the train station or in the train, as much as lost in a restaurant, or you know, somebody walks and it's lost. So that's your biggest risk. So what I would say is have a quick outline of what do you do if that USB is lost. For example, do you need to encrypt that data, which I think should be the case? If your organization, you have laptops, where that laptops, you know, what is the policy around the use of that laptop? If your employees are allowed to use them for personal purposes, they should have 2 accounts on that laptop. And none of those 2 accounts should have administrator rights. They should have standard rights. That's very much a cybersecurity aspect. You may want to listen to the seminar that I did before, because I raised those issues, how to protect against cybersecurity threat. That's your main risk. I don't really see any other risk, really.
Okay, great, thank you. In the example of the German Academy and Facebook, if the latter were more responsible, why was only the Academy fined? Does this expose weakness in the compliance with GDPR being exploited by big giants, where they can escape if they don't actually do breach but give platform to use?
Yeah, I mean, GDPR is not perfect, and I think the weakness that it has, there are 2 main weaknesses for me. There is that one. The fact it might not have been fined is also maybe linked with the way the lawsuit has been brought in. My main issue is that I'm not familiar with German law, So what you get before the EU Court of Justice is not necessarily what happened at first instance in Germany. And there's not enough writing yet on academic circles to know exactly why there was that difference. But there are two main weaknesses in GDPR. One is the supply chain. I think the basic rules are right, they're good, they are setting up the responsibility. I think their application has been under the radar by most supervisory authorities. And the other issue is the data protection impact assessment. These are, even if when they're mandatory, which is in very specific cases, they don't have to be published. I think that's a mistake. We should publish data protection impact assessment, and those assessments should not be limited to privacy risks. They should include right to health if it's applicable, discrimination, all the human rights that we have should be taken into account. And that's not yet the case. That's partially because it's new, partially because I think we haven't put the emphasis enough in compliance. So if you like, in my 4 steps of today, the compliance has been very much focusing on step 1. It's starting to focus on step 2. And I think it's not strong enough on step 3. And it has focused a bit more on step 4.
Great, thanks, Audrey. So are there provisions beyond financial penalties in case of deliberate GDPR mischief, collusion or repeated breach? So
when it's deliberate and collusion and repeat breach, as far as I remember, because I haven't checked very recently, it's only fines. There is no, in the GDPR text, for example, ending of the company, because sometimes in criminal law, a company can be made to literally end its trading. It's not the case in the GDPR text. That doesn't mean that local legislation, so national legislation, may want to go beyond that. But then you will be dependent on national legislation. And the GDPR doesn't forbid that variation, because it's a variation that brings more compliance, stricter compliance, rather than diluting the standard compliance of GDPR.
Okay, that's great. Really complex one there. Where can one find a list of the data attributes, in brackets variables, which have to be protected, please?
So yesterday, and the slides and the video will be available, I went through what personal data is. There is no list in the GDPR, so you really have to think about the data your organization is collecting and using, and literally put them. What I would do is think of the data the way you think normally, and then see how it relates to the legal categories.
And our last question here coming in, if we represent organizations who sign up as members and typically discuss about them at public health meetings, etc., what would we need to consider? We have data sharing agreements with local authorities, general consent with our members covering the purpose and use. Is this sufficient, Audrey?
It's probably very good already. You have to make sure data sharing agreements are good enough to protect the data. It's the same issue with standard clauses in contracts, standard contract. Consent, the question you have to make sure is it really the valid ground? I would say you may need a privacy policy. You may want to have a plan for data breaches. What do you do if there are data breaches? For example, because you've got the data sharing agreements with local authorities, how do you manage that relationship if you've got unauthorized access, which is more likely to be sending the wrong information to somebody or losing that information than actually having a hacker, looking at your database. That's, I would say, the main thing to think of.
Great, thanks ever so much, Audrey. So that really concludes today, and we'll go on to the final slide now, which has our contact details, as well as our social media channels, where we would love to join in the conversation online. So if you have any other questions that have come to light after today, send us a tweet at BLG Data Research, and one of our experts will get back to you. You can find us on LinkedIn. You can find a recording of this webinar on YouTube, which will probably be up next week once we finish formatting it. And you can email suggestions, comments, as well as your request for your certificate to blgdataresearch@essex.ac.uk. So thank you to all of you for today, and thank you to Audrey, Dr Guinchard, for your fantastic presentation and for helping everyone get to grips with the complex issue of GDPR and what they need to do to comply.
Well, thank you for listening, because that was a really, really heavy session. So I hope I haven't rattled for too long. Thank you very much for joining us. Thank you.
Thanks again, everyone. Bye, everyone.
Thank you, Laura. Thank you. Bye.